I'm not asking you to ask questions today, but if I don't get any questions, I get really worried. Because I can't believe that you've understood everything, or that there aren't just sort of questions in your mind about what I'm saying. So please ask questions. And all the teachers tell me the French students are terrified of speaking in class and asking questions. They're going to look stupid. I can tell you, I've been doing this for a long time, but every time I come here, I have stage fright, what you call the trac. Maybe I don't show it very much. But it's the same for everybody. So you mustn't feel shy. Even if it's hard to get it out, you can do it in French or English, but just ask the question. And if you really can't, well, come and see me afterwards. But the experience is that if you ask a question, it's almost certainly beneficial for everybody. Sometimes there are questions that I can't answer. I can't remember, or I've got to go and check. Doesn't matter. Just one practical point. I was talking with a colleague just now about PowerPoint. I may come along with a PowerPoint occasionally. If we do a PowerPoint, it'll be there to give you some of the technical words which are more difficult. And we'll try and get those PowerPoints circulated as well, copies. But it doesn't always happen immediately. But if you need anything, you can just ask if you feel you haven't got all the information you need. A lot of things are out there on the web. If you go to HM Courts and Tribunals Service, for example, all the .gov UK websites, there's a lot of information where you can cross-check vocabulary and stuff. I'll try and give you a list of websites as well, so that you can dip into that if you need to. You had a question.
Understand the difference between examination and cross-examination?
Okay, so the question is, what is the difference between examination and cross-examination? That's a really good question. What you have to imagine is that one of the parties wants to call a witness to try to prove a fact. So, in order to do that, you have to put your witness into the witness box and then ask the witness a series of prepared questions. And there are ethics, lawyers' ethics surrounding this. The barrister who asks the questions won't have seen the witness, because otherwise it would be too prepared. It's not like a kind of rehearsal for a theatre play. So there has to be a certain spontaneity in the question-answer process in court. So the barrister will have a list of questions that he or she wants to ask the witness to get to prove the fact that he or she wants to prove as part of the party's case. Once that process is finished, the other party, the defendant usually, who will come second, will then want to ask questions of the same witness. In other words, they want to test the credibility of the witness. They want to test the reliability of the evidence that has been given. In other words, they want to challenge the witness. And that is the cross-examination. Have I answered your question? Is that okay?
Even if there are very serious facts, there is no equivalent to our instruction, or I mean, it's all done in the trial. There is nothing done before.
Exactly. We do not have a juge d'instruction in criminal matters. As we'll see as we go on, the police will do the inquiry. They will try and collect the evidence that they think is relevant. And they will then give that evidence to the prosecutor. And the prosecutor will then present that evidence at the trial. So it's often said that the instruction se fait à l'audience in the English system. And yes, it's a bit like that, except that it's not the judge who is asking the questions. The judge, even in a very serious criminal trial, will be sitting and listening most of the time. The judge in a criminal trial in our country is there to manage the case, make sure that all the rules are followed, but does not take an active part in questioning or examining the witnesses. I can't quite hear. I always forget.
Is the prosecutor the same function as general attorney?
Okay. I'll just go back to the thing. You can still hear me? Yeah, the question was, is the prosecutor the same function as the general attorney? I think I'm not sure quite what the general attorney is, but the general attorney is probably something in the United States, where the lawyers are called attorneys and the prosecutors are district attorneys, or perhaps there are other kinds of attorney who do prosecutions in the States. I'm not very sure. In the English system, the prosecutor will be a solicitor or barrister. In other words, a member of one of the legal professions. And this is another thing that we'll see, another particularity of our system, is the involvement of lawyers in the whole system. And the lawyers in England, solicitors or barristers who are doing prosecutions, either they will work for something called the Crown Prosecution Service, so they will actually be employed by the Crown to do the prosecutions, or quite often, and particularly in very difficult cases, the Crown will engage usually a barrister, a very senior and experienced barrister to do the case, to do the prosecution for the Crown. So we have this very curious system looked at from this side of the channel, where we don't have a kind of career prosecuting system or career judges in the same way as you have in France. Does that answer the question? Yeah, we'll come back to that anyway.
Do you have to provide the list of witnesses and evidence to the other party?
I'm almost sure, yes. In other words, the idea is that there shouldn't be surprises unless something's happened at the last minute. I suppose it could happen, but then the other side would ask for an adjournment for time, just to prepare their response, or perhaps find another witness. That's it? Okay. So we have about a quarter of an hour left, which is not very much, but we'll start and see where we get to today. So really, I just want to go into a bit more detail of some of the things we've been talking about in the first half. And the first point is really what is the United Kingdom? Constitutional organization point. So the full name of the United Kingdom is the United Kingdom of Great Britain and Northern Ireland. And it's a constitutional monarchy with 4 countries. 4 countries: England, Wales, Scotland, and Northern Ireland. And just to make things simple, 3 legal systems: England and Wales, Scotland, and Northern Ireland. So, as I said earlier, we will be talking about the law of England and Wales only. There are a number of things that the 4 countries share in common. First of all, a hereditary monarch. The sovereign. Sometimes called the monarch. The queen. And sometimes referred to also as the crown. But the crown usually includes the government. But from a constitutional point of view, it is the sovereign, the monarch, who is the head of state. The second thing that the 4 countries share is an executive government based in Westminster. But some executive powers have now been devolved, particularly to Scotland and to Northern Ireland. The third thing that the 4 countries share is a parliament which is bicameral, partly elected, made up of 2 houses, Lords and Commons. And Parliament is the supreme legislative organ of the United Kingdom. But there has been devolution of some legislative power in domestic affairs to Scotland and Northern Ireland, which have their own assemblies. Wales also has an assembly, but with less power to legislate than Scotland and Northern Ireland. Executive, legislative, and judicial power, or powers, I should say, executive, legislative, and judicial powers are exercised in the name of the sovereign, in other words, the Queen. We've already said that the UK does not have a written constitution. And until 2005, we had no formal legal separation of powers. In 2005, a formal separation of powers was created between Parliament and the Supreme Court. Because until then, the final Court of Appeal was part of the Parliament. We'll come back to that. Just to say a brief word about Scotland. Scotland has its own civil and criminal law. I'll say that again. Scotland has its own civil and criminal law, which resembles, in some respects, English law, but is quite often different. And only civil appeals can be made from the Scottish courts to the Supreme Court in London. And just for the anecdote, when a Scottish civil appeal comes to London, the Supreme Court has a Scottish judge who sits with them to help them understand Scottish law. If you ever get involved with cases in Scotland, you'll find the legal language is different.
I didn't really understand what you said about civil appeal.
Yes. Okay. Well, the question is, what did I say about civil appeals from Scotland? I said that Scotland has its own civil and criminal law, which is different from the law in England and Wales. It is not possible to make a criminal appeal from Scotland to the Supreme Court in London, but it is possible to make a civil appeal. And I'm not going to go into it now, but the word civil in our system has a number of different meanings. We're much less disciplined in our terminology than you are in France, but civil in this context means everything else except criminal. And criminal means every kind of offence. So the word criminal doesn't not mean just very serious cases. If you park your car illegally in the street, it's a criminal offence, okay? So don't think we make a distinction between crimes and other things. You won't get any questions in the QCM, but just so you know, the Channel Islands and the Isle of Man, so Jersey, Guernsey, and the Isle of Man, are separate possessions of the English Crown. They have their own legal systems. And our role is to represent Jersey, Guernsey, and the Isle of Man in their international affairs. and defence. And they're not part of the European Union. I had a case in France recently that went to the Conseil d'État for a British client. It was all to do with decisions of the Employment Inspectorate and in France and in relation to redundancies of French employees. And one of the points that we wanted to argue in the Conseil d'État was the question of estoppel. You may have come across estoppel. It's a derivative of the French word étoupe, estoupai. It was the piece of cloth that you put in a bottle or a barrel to prevent the wine coming out before corks were used. And in Norman feudal law, there was a concept of estoppel, which meant that you couldn't contradict yourself in legal proceedings. If you've taken one position in a case, you can't change your position later. That's what's called estoppel. And you may know that the Cour de Cassation in France has adopted the principle of estoppel, but the Conseil d'État has not. So we were trying to persuade the Conseil d'État to adopt the principle of estoppel in this particular case. And just to show them that this wasn't some kind of strange Anglo-Saxon legal concept, we explained to them that it's actually a Norman law concept.